My clients are here because Amendment 3 does not meet the constitutional and statutory requirements for an initiative petition to be on the ballot. These requirements protect voters. They do not undermine the initiative petition process. They are set forth in the Constitution and the implementing statutes in order to protect all Missouri voters. They do not burden the state of Missouri's voters. They require them to be fully informed in order to properly exercise their rights within the initiative petition process. So if you find that that one of the repeals here was sufficiently direct that it should have been disclosed, then all you need to find in follow-up to find that it's squarely within the statute is that leaving out the information that, for instance, Amendment 3 would repeal our ban on abortion, or repeal Section 17, or 27, or 28, or 30, or 15, that leaving that out would have been misleading to the voters. Another way of saying that is, would a voter's mind have been changed? Would their position on this have been different if they had known that that was the effect of the statute? Now, if you want to look at the text with me, we can see whether an ordinary voter might know otherwise what was happening to abortion just by reading what's in the text. As appellants have repeatedly stated, all this text does is add. It just adds to the Constitution. It adds a new right that we should be very excited about. And then down in Section 4, it doesn't say we're going to limit abortion, we're going to prohibit abortion. In Section 4, it allows the General Assembly to regulate abortion. The average voter reading this would have no way of knowing that it has a limiting effect unless they were a lawyer and in Section 4 they thought to themselves, why do I need the General Assembly to have the right to limit abortion after viability? Did something in Sections 2 and 3 take that right away? This is a provision that does not reveal on its face what it's doing. Therefore, keeping from voters the fact that it makes such substantial repeals absolutely misled voters.
But more fundamentally, this court should simply dismiss this appeal because the appeal has now become moot. The Secretary yesterday decertified the ballot amendment, and I want to be clear that the Secretary's decision yesterday is not before this court because the interveners have not amended their pleadings or done anything like that to challenge the Secretary's actions. And so the Secretary reassessed, took a look at the Sweeney decision, and determined that the Sweeney decision authorizes him to do this as long as he makes a certification or decertification decision anytime before, at least 8 weeks before the election. So that's what he did. If they want to challenge that, they're free to go ahead and do that. They haven't challenged that as of this morning. So this is no different than if the Secretary had issued a decertification decision last Thursday, for example, having looked at the pretrial briefs, having determined that in fact he was wrong when he initially certified it. It's no different from that circumstance, and that's there.